The Supreme Court ruled that the SEC lacks clarity in the XRP case. Stuart Alderoty, the chief legal officer of Ripple, distributed a transcript from ongoing litigation involving the Securities and Exchange Commission on Wednesday. He said that when a judge states that the rules of the Securities and Exchange Commission are so ambiguous that no one knows whether they'll be at risk, she may be onto something. I don't know much about this proxy access case that was argued in the Fifth Circuit yesterday, but I did say that yes, it is a result of numerous damaging remarks made in court about the SEC. Though it seems unlikely, these claims, which seem to be the most recent ones, may draw the interest of American lawmakers, even if they don't affect how the SEC and Ripple litigation ends. 5 senators from the United States co-signed a letter in February that threatened the Securities and Exchange Commission with legislative oversight. Following a court order that the SEC provide evidence as to why it should not be punished for providing false and misleading testimony to the court, 5 senators, including Senator Cynthia Lummis, co-signed a letter in response to the Securities and Exchange Commission's filing of a motion to dismiss charges against DebtBox. An attempt was made to dismiss the case at the Securities and Exchange Commission's request. The courts are not the only body that has closely examined the SEC's operations. The Office of the Inspector General is nearly finished with its investigation into potential conflicts of interest involving cryptocurrency within the Securities and Exchange Commission. Should the Office of the Inspector General find that the Securities and Exchange Commission acted improperly, the SEC may decide not to pursue an appeal of the ruling regarding the programmatic sales of XRP. This is in accordance with Judge Annalisa Torres' ruling from July 2023, which the Commission has demonstrated since submitting a motion for interlocutory appeal in August 2023. Critics within the agency where the settlement was negotiated have taken issue with the recent agreement reached between the Securities and Exchange Commission SE and the Bitcoin business. Commissioners Hester Peer and Mark Ueda of the Securities and Exchange Commission SEC have recently made public statements expressing their dissatisfaction with the state of affairs as it stands. They contend that there has been ongoing uncertainty about the Securities and Exchange Commission's SEC approach to regulating cryptocurrencies, which is partly due to the SEC itself and this enforcement case in particular. The Federal Reserve, the Commissioner, maintained that despite this need, the SEC's recent action against Shapeshift failed to justify these classifications or specify which of the 79 crypto assets in question were classified as investment contracts. Peer and Ueda reached this result in order to challenge the SEC's application of the Ho test, which was developed in response to a 1946 U.S. Supreme Court case. According to Pand, the absence of a definition exacerbates misunderstandings over its categorization and laws in the Bitcoin industry. Pand thinks that this ambiguity is part of the reason why the enforcement method is currently being evaluated. This critique is not limited to only that. In addition, aside from the Shapeshift Taste Plan's implementation, which combines the SS with a more comprehensive approach to the enforcement of the crypto sector, moreover, the X has filed lawsuits against several other Bitcoin businesses over the course of the previous few years, including Coinbase and Binance. A large proportion of cryptocurrencies should be classified as securities, according to Securities and Exchange Commission Chairman Gary Gensler, and cryptocurrency platforms should register with the SEC in accordance with his suggestions. But according to Paris and the Ueda, this just come in and register approach lacks substance and clarity, especially when it comes to certain categories of cryptocurrency assets that are classified as securities, because everything else is affected by uncertainty in a cascading manner. Although the question of whether or not cryptocurrency-related assets must be treated as securities is not new, it has recently gained attention due to changes in the law. A recent ruling from an American court stated that trading some cryptocurrencies on secondary markets is the same as selling securities. Nonetheless, a sizable portion of those working in the Bitcoin industry believe that this choice was incorrect. The U.S. Securities and Exchange Commission is trying to take advantage of this decision in order to strengthen its case against Coinbase. Despite these challenges, the legal and regulatory issues that the Bitcoin industry is currently dealing with need to be highlighted. This is comparable to the recent litigation in which Ripple partially prevailed, since a judge determined that XRP sales to institutional investors were unlawful security sales but not blind bid sales to individual investors. Rejecting an interpretation of the Securities and Exchange Commission's decision, Coinbase claims that unconnected court decisions have no business influencing ongoing legal proceedings. The Securities and Exchange Commission (SEC) has announced that it is currently working on assembling its remedy-related brief as the protracted action against Ripple continues. This shows the intricate and constantly evolving nature of securities legislation in the context of cryptocurrencies. Whether or not investors will buy XRP tokens is still up in the air. Investors, in the meantime, are racing or flocking to networks with the potential to yield large returns. This has led to a spike in the number of people joining the Nugget Rush community, which has caused investors to purchase 206 million NS tokens. These investors are worried about NUC's ability to stay upbeat in the face of competition from top DeFi ventures. For further Order Nugget details, continue reading. You must get in touch with the SEC as soon as possible to request a time extension. There are some disagreements going on in the XRP community right now. In the event that the regulatory agency submits a request at a late hour, an additional extension for the ongoing litigation between XRP and the SEC may be granted. Furthermore, a request to extend the deadline for filing the Securities and Exchange Commission's remedy-related brief was made on February 28, 2024. In an attempt to extend the deadline, this request was made. The community's level of tension will rise if Grant Ed's motion is granted, as it would cause the XRP litigation to be postponed for longer. The extension request that was submitted by CC is the result of a somewhat upward trend in the value of the cryptocurrency XRP throughout February. The current price of XRP on January 20th was $5,531. It dropped 8.5 cents to 559 cents on the first day of February. On February 14th, the value of the XRP coin saw a recovery of 6.4, reaching a value of 534. On February 29th, it found itself at 58 cents, up 8.8% from the day before. Notwithstanding the controversy surrounding the pending case in which they are involved, the team behind XRP has already improved their Ripple Pay services. Notwithstanding the uproar surrounding the lawsuit, XRP has moved forward with its plans to broaden its payment capabilities. The company has also acquired a Bitcoin asset holder that targets institutional investors. At the moment, XRP is worth analysts predict that the company's value may rise from $7.99 to $21.0 if it were to expand its offerings. Nevertheless, there are substantial differences regarding whether XRP is a viable cryptocurrency that can be purchased right now. This will result in investors being encouraged to invest in other popular cryptocurrencies. Comparing the number of projects that follow this method to the number of projects that adopt such an innovative strategy, some experts consider that the latter are unlikely to result in commercial dominance. Employees at Nugget Rush are employing a mind-to-earn approach, which attracts investors because the gaming industry is always changing and new peer-to-peer alternative cryptocurrencies are being introduced on a daily basis. Nonetheless, there aren't many projects that employ this kind of creative thinking. Programs like Nugget Rush, which don't use laser light, are one of many that are currently breaking away from the pattern. Built on the cryptocurrency Ethereum, Nugget Rush is an ecosystem focused on Ethereum mining. Around the world, it encourages and supports artisanal mining-related activities. Players that participate in the Nugget Rush Nug's presence also have the chance to win money and, at the same time, make financial donations to artisanal mining groups that are spread throughout different parts of the globe.